Welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about those laws, please feel free to reach out to us at any time. We also help the Commissioner with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it's on the page where you registered. We also record all of our webinars, and we're recording right now, so if you missed part of today's webinar or want to go back and watch it again, or find one of our prior series, they're posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. We also have a dedicated body camera information page on our website, including an outline of body camera requirements and frequently asked questions. So since you're here today to learn about body cameras, that might be a useful resource for you as well. If you would like to download a copy of the PowerPoint right now, I'm about to share a file for you to download and save to your own computer. One second here. Okay, so you should see a pop-up on your screen, and you can select the file and download it to your own device. I'll give you a couple seconds to do that. You'll also have time at the end of the webinar, and it will be available on our website. All right, so today's webinar is another installment of Data Practices Potpourri, where we highlight some of the questions that we get. Here we're going to be focusing on body cameras and a body camera overview, as well as some frequently asked questions specifically about body cameras. So as we're going, we're going to leave some time for a Q&A session at the end. Please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so we can be sure to see them. And you can start sending them in now, or you can wait until the very end of the presentation to send them in. So let's get into the classification of body camera videos. Body camera videos are governed by Minnesota Statute section 13.825 and are treated differently than other law enforcement data. Most other law enforcement data are generally governed by 1382, but due to the nature of body camera footage and the fact that these cameras are worn while entering people's homes, unlike dash camera footage, the legislature determined that body camera videos should have additional protections. If body camera data are at issue, the classification of the body camera data will depend on whether the law enforcement investigation is active or inactive. If the investigation is active, 13.825 subdivision 2A3 indicates that the body camera data are governed by 1382 subdivision 7 while the investigation is active. This means that when there is an active criminal investigation, body camera data become confidential active investigative data. Data that are confidential or protected non-public are inaccessible to the data subject and can only be accessed by those within the government entity with a work assignment or those with statutory authority or a court order. However, once that criminal investigation becomes inactive, then the body camera data revert back to 13.825, which generally classifies body camera data as private or non-public, which I'll talk about in greater detail in the next slide. However, in certain situations, inactive body camera data become public if they document an incident where an officer discharges a weapon in the course of duty, not including training or killing an animal. The data documents the use of force by a peace officer that results in substantial bodily harm. A data subject of the body camera data may make the video public. However, if the body camera footage documents other data subjects who have not provided that consent to the release, and they're not peace officers, those individuals must be redacted from that video. And body camera data that are public personnel data under 1343 subdivision 2, so that personnel data section, remain public, which as a public employee would be disciplinary data. Subdivision 2 also mentions that body camera data may be redacted if it's clearly offensive to common sensibilities. Law enforcement agencies may also release any not public body camera data to the public to aid law enforcement, promote public safety, or dispel rumor or unrest under 1382 subdivision 7. So that's that public benefit data section. This provision is generally what we've seen law enforcement agencies rely on when releasing body camera footage while a criminal investigation is still active. Whether law enforcement used a body camera or any portable recording system is also a public element in the context of arrest data and response or incident data. So this is why it's important to first analyze whether the investigation is active or inactive. Body camera data that are inactive investigative data and do not fall within one of those 4 public exceptions that's listed on the last slide and in 13.825 subdivision 2 are generally classified as private or non-public. When government data are private or non-public, the data are accessible to the data subjects, those within the government entity with a work assignment, and those with statutory authority or a court order. 13.825 subdivision 4 discusses access to body camera footage by data subjects. And now this subdivision indicates that data subjects have access to private or non-public video. So an individual whose image or voice appears in a body camera video can view the unredacted video, including viewing other individuals and peace officers who appear in the video, except for undercover peace officers. So it's important to note here that the access or right to view the data under the subdivision is different than the data subject's right to obtain copies of the data. The data subject may only view the unredacted footage, but if they want copies of body camera videos in which they appear, the identities of the other data subjects must be redacted. So this is an important difference between body camera footage and other private data that government entities maintain. And it's due to the specific data subject and access language in this provision that does not exist elsewhere in the Data Practices Act. So again, if a data subject requests body camera video be made accessible to the public, other data subjects, not including on-duty peace officers engaged in an investigation or response, must either give consent or they must be redacted from the video. Law enforcement agencies must always redact undercover officers from body camera videos. So as far as retention, generally entities rely on their retention schedules to determine how long they have to keep official records. However, 13.825, so this body camera section, imposes minimum retention requirements for body camera videos. All body camera videos must be retained for at least 90 days. If body camera data document use of force, discharge of a weapon in the course of duty, or there was a formal complaint against an officer, the videos must be retained for a minimum of 1 year. So once these 90-day and 1-year thresholds are met, the law enforcement agencies must then follow their own retention schedules, which might require longer retention of the videos. However, 13.825 also indicates that entities must allow data subjects to request longer retention periods for body camera videos. So the entity's required policies should provide data subjects information regarding the process for asking for this extended retention. And the entity's internal procedures should account for retaining body camera data for these minimum periods of time, so that 90-day and 1 year, and the extended retention requirements, in addition to their usual retention schedule requirements. There are quite a few additional requirements outlined in 13.825 that law enforcement agencies must follow if they use body cameras. I have them listed on this slide here by subdivision, so you can quickly reference them if you need to. But law enforcement must maintain an inventory, which contains public data about the number of body cameras the agency owns, daily records of the cameras used, and the precincts in which they were used, policies and procedures for use, the total amount of video data collected, the agency's retention schedule for body camera data, and the agency's destruction procedures. Per subdivision 7 of 13.825, the responsible authority for law enforcement agencies must have written procedures that specifically outline access to body camera data. These procedures must ensure that law enforcement personnel only have access to not public body camera footage if authorized in writing by the head of the law enforcement agency or their designee for a legitimate specified law enforcement purpose. Body camera data also may only be shared with or disseminated to another law enforcement agency, government entity, or federal agency upon meeting the standards for requesting access to data as provided in subdivision 7, so that authorized access. Law enforcement agencies must also arrange independent biennial audits of their body camera data and whether they are appropriately classified, how the data are used, whether the data are properly destroyed, and verify compliance with subdivisions 7, 8, and 9. Law enforcement agencies must provide the reports summarizing the results of each of these audits to certain legislative committees within 60 days of the completed audit as well. If law enforcement agencies obtain new surveillance technology that expands the scope of their surveillance capability with body cameras beyond the scope of video or audio recording, they must also notify the BCA within 10 days. There are certain vendor requirements as well outlined in subdivision 11 and also increased penalties for willful violations in subdivision 12. I also have section 626.8473 listed here, and that section requires law enforcement agencies to allow for public comment and create written policies and procedures before it purchases body cameras or implements a body camera program. So these are just important things to be aware of. So the Commissioner of Administration issued an advisory opinion 20-004 which discusses the classification of body camera data during an active criminal investigation. In this opinion, the Commissioner states that active criminal investigative data are not classified by Section 13.825. Instead, active investigative body camera data are classified by Section 1382, Subdivision 7. Once the investigation becomes inactive body camera data are classified as provided in Section 13.825. In this situation, the body camera data were part of an active investigation into the actions of officers responding to a call for assistance. Therefore, the body camera data and other law enforcement active investigative data are classified as confidential or protected non-public until the investigation is inactive when it reverts back to 13.825. All of our advisory opinions are on our website, and so if you would like to read this opinion for additional context or more information, it is on our website and available for you to review. Oops. Okay, so we're going to get to our questions. I previewed our answers there quickly, but we'll just start from question 1. So now that we've discussed active versus inactive classification, we'll also look at some questions regarding inactive body camera data. So this first question is, I have an inactive case where a vehicle was towed due to trespassing. The vehicle owner is claiming that the tow company damaged the vehicle. The tow company now wants a copy of body camera footage. Are they entitled to it? So only data subjects can access body camera footage. The main question here is, who are the individuals that are seen and heard in this body camera footage? Those are the data subjects. Here, there are likely tow company employees in the footage and also on-duty peace officers. If the tow company would like to access this body camera footage, they would need to provide written informed consent of the tow company employees that are seen or heard in the footage and any other data subjects who do not provide written informed consent would need to be redacted, other than on-duty peace officers. On-duty peace officers may not be redacted from private body camera data unless they are undercover officers whose identities are protected pursuant to 1382 subdivision 17. Similarly, we receive questions regarding ambulance personnel or medical providers and whether they need to be redacted from body camera footage when providing a copy to a data subject. The analysis would be along the same lines. If the ambulance personnel and/or medical providers can be seen or heard in the body camera footage, they are considered data subjects, and their image or voice should be redacted from any copies of private body camera data that are released to other data subjects. Whether you have a tow company or some other requester that's not a data subject, you are looking for that informed consent, and informed consent requirements are outlined in the Minnesota rules. I've cited the specific Minnesota rule that's applicable here on this slide. It's Minnesota Rule 1205.1400 subpart 3. And it goes into detail for the requirements of informed consent for accessing private data. So again, just because the tow company is a business and they have an interest in this video, they're not a data subject, so they can't just immediately get access to the employees pictured. It's the individuals who are the data subjects here, and they have to provide that written informed consent. All right, our next question. A data subject asked whether they may bring someone with them who is not a data subject to view or inspect private body camera videos. Is this permissible? No. Only data subjects may access or view private or non-public body camera video in its unredacted format. This right does not extend to other individuals who are not data subjects. If the data subject requests a copy of the body camera footage and all other data subjects are redacted, the requester may then share the redacted body camera video with anyone. On a related note, we received a question asking whether a data subject may bring an interpreter with them to view unredacted body camera videos. The Data Practices Act does not address translation services. There may be obligations outside of the Data Practices Act for government entities to provide translation services or access to information or data in another language. If the government entity contracts with interpreters to provide access to information or data in other languages, the interpreter could be pulled into the entity for purposes of data practices as an independent contractor or employee. And the interpreter would be subject to the same requirements other government employees are in protecting non-public government data. However, if a data subject wants to bring their own interpreter, the interpreter is likely functioning as a member of the public and would likely need to need the written informed consent of other data subjects in the video, absent some other statutory authority or obligation to provide translation services in this way, which would fall outside the scope of our authority. Okay, our third question. Can parents access private body camera footage of their minor child? So, the Data Practices Act definition of an individual includes a parent or guardian. So as a result, parents or guardians may access private body camera footage on their minor children. However, it's also worth noting that minors can request that their private data be withheld from their parents' guardians. So the Minnesota rules, again, they're listed on the slide here, provide additional guidance regarding access to private data on a minor's request for their data be withheld from their parents or guardians, and the factors an entity should consider when determining whether to honor the minor's request to deny parental access to private data. Okay, so Let's take a look at a scenario involving another type of body camera situation. Here, an entity received a data request for a copy of body camera video from a data subject. The data subject appears in 5 minutes of the 60-minute recording. The question is, does the entity need to provide all 60 minutes of the video data with applicable redactions, or can the entity provide only the 5 minutes where the data subject appears? Again, with any needed redactions, and trim away that remaining 55 minutes of the video. So here, the entity should likely provide only the 5 minutes of data where the data subject can be seen or heard. The remaining 55 minutes could be removed. So let's walk through this analysis. It's a really common question that we get. So a general reminder, the Data Practices Act classifies data elements rather than media formats or documents. So we shouldn't be thinking about access to the body camera recording as a whole. Rather, the focus should be on the specific content of the data documented in that recording. Minnesota Statute 13.825, so the body camera provision, does not provide guidance on how much context of the video must be provided to a data subject. It instead discusses access based upon the content of the video. So section 13.825, subdivision 4A, defines who a data subject is in body camera data, which is any individual whose image or voice is documented in that data. So in other words, individuals are data subjects of body camera data when they can be seen or heard. And then section 13.825 subdivision 4B describes the access procedures. So it states that an individual who is the subject of the portable recording system data has access to the data. So an individual has access to specific data, which they are the subject, not all data contained in a video or recording. Taking all that together, the outcomes that a data subject can only access portions of the recording where they can be seen or heard. If the subject wants a copy of those portions, the entity needs to redact other subjects except for on-duty officers who are not undercover. The remaining portions of the video where the subject cannot be seen or heard can be removed. And I think this goes somewhat to the nature of body camera footage. Officers are wearing these footage wherever they're walking. They could be at a neighbor's house and then walk to somebody else's house next door. And so that neighbor might be in the first 10 minutes of the body camera footage. And they're outside, they're talking to the officers. But once they go inside their next door neighbor's house, so another individual, they're no longer able to be seen or heard in that video. Now the subjects of that body camera footage, where that camera is still on, are a different family and it's a different situation. So you're not necessarily the subject of an entire video or recording. It's more likely that you're subject to subsets of videos or recordings. Okay, another question here. Do the same classifications and requirements in Minnesota Statute 13.825 apply to other video that law enforcement agencies may maintain, such as squad camera video? So no, Minnesota Statutes 13.825 only applies to body camera data. Most other law enforcement data and videos, such as squad camera videos, are governed by 1382, with the exception of certain drone data governed by 626.19, and automated license plate reader data governed by 13.824. So that is our overview of body camera videos and questions we've received. We have time to discuss any questions that you all have. Please remember to send them to all panelists so we can make sure to see them. If you are silent during this open question and answer period, we're reading your questions. A few reminders on the slide that the slide deck is available on our website and you can access the recording on our YouTube page in the next couple of days. I will also be putting an evaluation in the polling panel. And so when that's posted, if you could fill that out and let us know what other topics you'd like to see in this future and how we're doing, that would be great. Again, please type your answers or questions in the Q&A panel, and I am going to post our PowerPoint to share it one more time for those of you who might have missed it the first time around.
All right, so yes, we'll get started with the Q&A session. And just one note here, we do have several questions already, but feel free to keep sending those in. Remember to send them to all panelists. If we don't answer your question, we will be sure to follow up with you. One of the things with body camera data is that it's very complicated at times, and it sometimes depends on very specific facts. And so if it's a really specific question, we're happy to follow up with you, or feel free to reach out to us and we'll be sure to answer your questions as best we can. But we'll get started here with the Q&A, some of the questions we have. So the first question here is that an agency has a subject who received a citation, but the subject has not yet paid the citation, but wants a copy of the body camera video. They're not contesting the citation, they just want to see the video, presumably. Can they have access to the video prior to the citation being paid and case closed? In this situation, probably not. Remember that when it comes to body camera videos that are part of an active investigation, those are going to be classified by 13.82 subdivision 7. And so 13.825 subdivision 2 says active investigative data, or active body camera videos that are part of an active investigation are classified under 1382 subdivision 7. So in this situation, the data are probably still confidential and wouldn't be accessible to the data subject until after the investigation becomes inactive. Okay, a second question we have here is that someone has a DWI accident case that the suspect passed away and the victim wants body-worn camera footage. Her attorney has sent a request for all body-worn camera and squad video, and there are 8 officers on scene. What do we have to release to them? So here, you've got 2 different types of videos. And so, the squad camera video, squad footage video does not fall under 13.82. And so you treat squad car video similarly to how you would treat any sort of other data under 13.82. And so if there's an active investigation, much of that data may be confidential, but then some of the data, the public data would be, available under subdivisions 2, 3, and 6. I'm not sure if any of that would fall within that squad video area there. But as for the body-worn camera video, again, if the case is still active, 13.825 subdivision 7 applies. But remember, under 1382, subdivision 13, there is access to data by crime victims if they make a request to the prosecuting authority. And so this kind of gets a little tricky with body camera footage. And I think it requires some analysis and probably working with legal counsel on this to determine whether or not that provision applies. Our view at the Data Practices Office is that body camera footage is treated a little bit differently than all other types of law enforcement data because of 13.825. And so, not necessarily sure that you could disclose body camera footage under those provisions in 13.82 subdivision 13, the access for data for crime victims. That said, 13.82 subdivision 15 is the public benefit data provision, which does allow law enforcement agencies to disclose body camera footage as well as any confidential or protected non-public data classified under subdivision 7 of 13.82. They can disclose that if it will aid the law enforcement process, promote public safety, or dispel widespread rumor or unrest. And so in this situation, I think it's going to take a little bit of an analysis. And if you want to give our office a call, we're happy to walk through that. But a related question, and somebody else had this one too, is getting requests from data subjects' attorneys. Again, with body camera footage, those data are classified as private. And so before you can disclose those data to a data subject's attorney, you probably would need to obtain informed consent from the data subject. When it comes to going into the agency to inspect the data, to review the unredacted versions of the data, that right, at least in our view, doesn't transfer over to the attorney. So it's only the data subject that can view the unredacted versions of the data, body camera data at your office. But when it comes to copies, you can still have the data subject give informed consent or obtain informed consent from the data subject to release the data to the data subject's attorney. So it's a little complicated, but hopefully that gets to the kind of the core of the question there.
Okay, now we have a question from a data requester who said that they've been asking for some body camera footage for a police-involved shooting that occurred March of 2021, and they're still looking to get access. And the question is whether body camera footage that's part of a BCA investigation is retained longer than the 1-year requirement in this circumstance. And if so, how much longer? So again, we went through all of the required retention in section 13.825, and it varies according to circumstance. But body camera footage that is included in an investigation is likely going to be retained for longer and retained according to that law enforcement agency's records retention schedule provision regarding investigative materials, active investigative materials. And so largely those kind of shorter retention periods are probably for the body camera videos that aren't necessarily involved in an investigation. Once something goes further and maybe goes to court, etc., those records are likely retained for longer. So in this circumstance, it is possible that data is still part of an active investigation, and in which case it's confidential and protected non-public, which means that the public and data subjects cannot have access to it as it's part of that investigation.
We also had a question. We have an agency policy that requires notarized consent form for all data subjects to receive a copy of their body-worn camera. Can we also require the same notarized consent form if data subject is only requesting to inspect? It followed up and said that they require the notarized consent to confirm identity for other data subject requests. So there's always an obligation to verify identities when an individual is requesting data on themselves, because you have an obligation to protect that private data on individuals. Only the data subject may access that data and those within the entity or those with statutory authority. So you have to make sure this person is who they say they are. If your policy, your data access policy, say that one of your methods for verifying identity is a notarized form, then that is fine. And you can choose what your method to verify identity is. It should just be in your access policies.
Okay, another question we have here is, can a subject of the data record the footage with a phone or recording device they are inspecting during the inspection? So really, can the data subject record the unredacted version of the body camera data when they're in person inspecting? And the answer is no. This is kind of one of the exceptions under the Data Practices Act, where most times if somebody came in and inspected data, they might be able to take pictures or make recordings of other types of data. Here, I think the appropriate policy or the appropriate balance is that, the data subject has a special right to view unredacted versions of data, private data on others, and so that does limit their ability to record that. So if you do have someone coming in and inspecting unredacted versions of body camera data, you cannot allow them to use a phone or other type of recording device to make their own copies.
Okay, we had another question about retention, which is for the retention of body camera videos when there is a formal complaint on an officer. Does the 1 year start from the time of the incident or the time of the formal complaint? So I think that the times on your retention schedules, if you're in government, are from the time of creation. And so I think it's from the time of creation, and then you have that 90-day window, minimum window where the body camera videos need to be kept. Some law enforcement agencies might have a longer retention period, and that's fine too. But for that minimum 1 year period, I think it starts at the time of creation, and then the complaint would come in that window where the body camera exists, and then it would expire at the end of that 1 year. But if it gets pulled into some other kind of investigation, whether it's a personnel investigation or a law enforcement investigation again, or a criminal investigation, then again, the time might be extended because now it's become part of a different kind of record.
We have another question. We have body camera data on a person who is now deceased. May next of kin receive the body camera data on behalf of the data subject? So when you are maintaining data on an individual who is now deceased, we look to Minnesota Statute 13.10, so 1310, which is the data on decedent section. That section states that it classifies private data on decedents, which means that private data on decedents are data which prior to the death of the data subject were classified as private. After that person is deceased, representatives of the estate during administration will have access to the data. If the estate has been closed, generally it changes to the surviving spouse, any child of the decedent, or if there's no surviving spouse or children, parents of the decedent. So I would refer you to 1310, and that will walk through who has access in different situations.
All right, we had a question about plainclothes officers. So how should plainclothes detectives be considered if they're not actually undercover agents according to the statutes? Should they be redacted? Are they considered the same? That's a great question, and it might be somewhat dependent on what plainclothes detectives, how their jobs differ. But essentially, if they are not undercover agents or officers in those circumstances, then they should not be redacted. So unless they have that kind of undercover officer role, then they should not be redacted.
Okay, and another question we have here is how wide is the scope of audio redaction in inactive cases? Is literally anything said by non-data subjects supposed to be redacted, or just identifiable things said by them, their name, addresses, etc.? This is a great question, and as a general rule, redaction is an art, it's not a science, and so it does probably take some discretion on your part when going through and reviewing the data. That said, I think going to the question about, what data subjects can access, whether it's the 5 minutes or the 60 minutes, I think that applies again here. And so the data subject is only entitled to the data that they can be seen or heard. And so if there is some other identifying data, there's a conversation or people are speaking over each other, then perhaps you probably don't have the ability to redact some of that about the other data subject. But let's say, talking with data subject A, they're no longer there, and the officer goes and talks with data subject B, and then some of that information, get some information there, then you're likely need to redact. And so again, I would say use reasonable judgment here because there's not a clear answer in 13.825 on what should be redacted and what shouldn't. But to the extent, you do need to provide access to the data subject who's requesting the data and then doing your best to redact out any sort of other data that would be about a different individual. And so that can go beyond name and address, potentially where they could be heard. And so it's discretionary, and the best rule is to do your best to be reasonable on that.
Another question, is it up to the agency to contact others in the video to get informed consent from the other data subjects? So when you have multiple data subjects in the video, generally your obligation is to redact that private data on other individuals unless they provided written informed consent. 13.825 does not contain an affirmative duty to go out to the other data subjects and obtain their informed consent or try to solicit that informed consent in order to release an unredacted copy to other individuals. I guess the agency could decide to do that if they felt that that would be beneficial, but there is no obligation to go out and seek informed consent if somebody didn't volunteer it to you.
All right, these are great questions. Keep them coming. We have a lot of them. We have a question about access by minors who then become adults. So if a subject is under 18 at the time of the recording but turns 18 before their parents request to view the footage, would the parents still have access because the data subject was a minor at the time? So no, the answer is once someone turns 18 and becomes an adult, if they are not under some sort of other type of guardianship, if they just turn 18 and become an adult, their data access rights all transfer to them and the parents can no longer have access. So even though it occurred, this would be the same as any other type of peace officer records on children that might be private. Once the person turns 18, the access rights are sort of vested with that adult now, and the parents no longer have access.
Another question we have here, can the subject of the video bring in the legal representative or an insurance representative to view the video with them or in place of them? answered this a little bit earlier, but just adding the insurance representative, really the ability for a data subject to view the data unredacted, come in and inspect it, is really limited to the data subject. And so they can't bring in any additional people with them, whether it's a legal representative or an insurance representative. If an attorney or an insurance representative wants to access the data, then perhaps the best solution in that situation is to provide a copy to the data subject with applicable redactions, or have the data subject provide informed consent so that their attorney or insurance representative can access the appropriate data, again, with applicable redactions.
Another question here. So once a request for body camera data has been made, are we under any time constraints in providing the data? Yes. So usually it's a data subject who's making the data request for their own body camera footage. In order to respond to data subject requests, government entities must respond within 10 business days. If you did have a public data requester, maybe for one of those four public in situations where body camera data do become public, you have a reasonable amount of time to respond to public requesters, but it's always 10 business days for data subjects.
So we do have a couple of questions in here related to cases and working with the prosecuting attorney or the county attorney's office on what should be redacted and what shouldn't. With these types of questions, I think whether you need to provide redacted copies of the data to the county attorney, or who's responsible for providing the defendant who might be representing themselves, with the appropriate body worn camera data. I think really that's going to be a conversation that you should have with the appropriate prosecuting attorney or the county attorney's office, just to get everyone on the same page. The attorney's office, is functioning as a government entity, or as kind of, you're working with that office together in order to carry out your work. So the attorneys themselves would likely have access to all of the unredacted versions of the body camera data, because they have a work assignment to access, confidential data as they're doing their roles in part of the law enforcement process. But when it comes to, who should specifically be providing data to defendants, or whether certain data should be redacted before providing that or being disclosed, I think that's probably an internal conversation that you should be having with the prosecuting office. And I don't know, or the prosecutor's office, and we don't have any specific guidance there. And so the best advice is, be in touch with the county attorney's office, talk with the prosecutors, and make sure those lines of communication are open, so everybody's on the same page about how to best handle these types of requests or disclosures when it comes to body camera data or any other law enforcement data for that matter.
All right, we have a question about protected identities, and I'm going to take this one and just preface it by saying that this is a difficult and unclear situation. And I think for those of you who are on this webinar and asking questions, you understand that there are a number of gaps in 13.825 where things might not be as clear as they could be. So the question is, let me find it. Well, regarding a criminal sexual conduct investigation that is now inactive, do subjects' identities remain protected in body camera footage that would normally be covered or protected under 1382 subdivision 17. So as most of you likely know, under 13.82 subdivision 17, victims or alleged victims of criminal sexual conduct or sex trafficking are automatically provided protection, and their identities are going to be redacted from any squad car video, any written testimony or investigative notes. Their identities are protected automatically. It is not clear in 13.825, the body camera statute, how those protected identities interact with body camera footage, because the only identity that is called out in 13.825 is undercover officers. That said, it is therefore a risk assessment for each law enforcement agency to determine whether those identities under 13.82 subdivision 17, including the protection of identities of victims or alleged victims of criminal sexual conduct, should continue to be protected and redacted when providing data subject access. Now, generally, if the case has not gone to court, if the video has not been presented as evidence in court and become public that way, the body camera video, once the data are inactive, would just be private. And so, as discussed before, data subjects have rights to access to either view it or to get copies. But whether someone who comes in who is not the victim can see the person or hear the person that is the victim is a determination for each agency to make, and how those two statutes aren't quite parallel.
These are some great questions. Thank you all for sending in your questions today. We have a couple that we didn't get to, but we've reached our time for today. So if we did not answer your question, we will reach out to you individually to get a response to you. In the meantime, stay tuned for our Gov Delivery notice for our next webinar. And please, if you want to review or if you want to look at any of our other YouTube videos, they're on our website. The materials will be posted on our website as well. Again, thank you for attending today. If you haven't already filled out the poll and provided your feedback on what other types of webinars you'd like to see from us or how we did today, please go ahead and fill that out. Thank you.